All right, good afternoon, everyone. We are on the record. I'm actually going to call both cases here. We've got some issues relating to these two companion cases. KCR 2221-1623, State versus Chad Guy Daybell, and KCR 2221-1624, State versus Lori Vallow, aka Lori Green Daybell. On the record. All right, appearing, we've got Rachel Smith for the state, Rob Wood and Lindsay Blake also, Mark Means from Ms. Vallow, and Jim Archibald. Also present is defendant Mr. Daybell and his attorney, Mr. Pryor. We are recording this on the court's FTR system, as well as it's being reported by our court reporter, and it's also being live streamed on the YouTube channel of the Idaho Supreme Court for public access to this hearing. So the first matter I want to call up today is in relation to the CR 2221-1624 case, State versus Lori Vallow. In that case, we had a hearing last week on August 30th relating to the commitment order that was issued by the court. We continued that to today, and I extended temporarily the commitment order awaiting a progress report from Department of Health and Welfare relating to the current competency of, or not competency of, the defendant, Ms. Vallow. The court has since received a progress report dated September 1st and reviewed that. So let me just verify first, Mr. Means, have you had an opportunity to receive and review the progress report?
I have, Your Honor.
All right, and Mr. Archibald, have you seen that as well?
Yes.
All right, I'll ask a representative from the state then whoever wants to respond. Has the state also received the progress report?
We have, Your Honor.
Very well. The court's considered the progress report in this case. It's at this status conference, I think, just a determination for the court to indicate whether or not the commitment order would be continued. Based on the progress report the court has received and the information from the Department of Health and Welfare, the court does find and determine at this time that pursuant to Idaho Code 18212, the defendant, Ms. Vallow, is still not competent to proceed with the proceedings in this case. So this case will be stayed pursuant to statute for an additional 180 days. And during that time period, then if another progress report comes in indicating restoration to competency, then we'll schedule a hearing sooner. If not, then we will set another status conference at 180 days to again review the progress of whether or not Ms. Vallow would be deemed competent to proceed with trial. So I'll be entering an order to that effect, which will effectively stay that case then for that additional 180-day time frame. So that will be the order on that. Any questions on that order, Mr. Means or Mr. Archibald?
No, Your Honor.
No, Your Honor.
All right, Mr. Wood, Ms. Smith, or Ms. Blake, any questions on the court's order regarding the 18212 proceedings?
No.
All right, thanks, counsel. We'll get that order entered in the case then. There's a few other issues I wanted to bring up on the record then relating to Mr. Daybell's case, who again is here present with counsel. We have a trial in the case that's scheduled for November 8th, so 2 months from today. In the intervening time period, we've got some motions that would be heard. We've got a change of venue motion scheduled October 5th and 6th. There's also just been filed a motion for severance. And further, the grand jury transcripts are, as I understand it, almost completed, but not yet completed and submitted to counsel, which are necessary for review by the defense as well as the state in order to go forward. Those are not done. And so given all those circumstances, counsel, I know we've discussed this previously informally, but it would appear to me, one other important point I guess I'll bring up, there was a waiver of speedy trial filed by Mr. Daybell on August 20th. And so given all those considerations, it would appear to me that really it would be impractical to try to commence this case 2 months from today on November 8th. I understand there may also be some discovery issues that are not yet completed. So the court really on its own motion feels like it's probably appropriate to continue this trial. And so that's where I think we're headed. But before I go ahead and make that final decision, I'll just ask first from the state, is there any objection to us vacating and rescheduling the trial in this case to allow for additional motion hearing?
There is not an objection, Your Honor.
All right, Mr. Pryor, have you spoken to your client about the possible continuance of the trial in this case?
Judge, I've discussed with him and done my due diligence. There's no objection.
Okay, without any objection, then that's just the reality of where we are in this process. I know there's a large amount of discovery and other probably significant motions that need to be heard. So the court is going to vacate the trial currently scheduled for November 8th. What I'd like to do is get one more trial date scheduled that would be the date that will stick. In order to get a date that we know is going to work and we can stick with, I think it's going to be necessary for us to set a scheduling conference after the change of venue motion, because depending on if venue is changed or not, that could have an effect on our scheduling. So I will reach out to counsel and we'll set up a scheduling conference sometime after the October 5th and 6th change of venue hearing, and we'll get the matter reset for trial after that motion's been determined. So that'll be the ruling on the current trial setting. Any questions on that, Mr. Pryor?
No questions, Your Honor.
Any questions from the state on that regarding the trial setting?
No, Your Honor.
No, Your Honor.
All right, thanks, counsel. So related to that then, Mr. Pryor, you filed a renewed motion to extend time under 12B for motions to be filed and heard. The state filed a response basically indicating no objection if the trial were to be moved. Since the trial's been moved, then I think the motion is well-founded and without objection from the state, then the court will grant your motion to extend time for 12B6 motions to be filed and heard in the case. The deadline on that will not be scheduled until we get our trial setting, and then we'll look at setting a time frame on the 12B6 cutoff once trial is scheduled. So I'll enter an order granting your motion to extend time on that.
Thank you, Your Honor.
All right, I think that pretty much covers all we needed to go through on the hearings for today on the record. Is that correct, counsel? Was there anything else we discussed that we need to bring up, Mr. Wood?
I don't believe so, Your Honor. I think that's it.
All right, Mr. Means or Mr. Pryor, Mr. Archibald, anything else from the defense on the record today?
I don't think so, Your Honor.
I don't believe so, Judge.
Okay, thanks, counsel. We'll go ahead and go off the record then at this time.